Any mention?
Yes. My lord, I beg to mention one unlisted item for tomorrow, my lord. It's against some eviction notice being issued to me.
By whom? MTC?
Without even hearing me. Not my lord, no, not MTC. Not MTC, my lord.
By whom?
By the recovery officer DRT, my lord. Here what has happened, my lord, there was an order passed by your lordship. On the basis of wrong submission made by the respondent bank, my lord, they were issued this eviction notice. There was a review petition filed by us, my lord, which was allowed to a limited extent. Now what the respondent bank tells before the recovery officer is that the review petition was dismissed and was not entertained by the court. And on that premise, my lord, this eviction notice was issued by the recovery officer.
Where's the property?
Property is in Kitting.
The same
matter.
Manik Dhar?
Yes.
Oh God, that's a sad case.
Well, it's big. And this happened all the while when we were in the process of filing an appeal, my lord, statutory appeal, without hearing us.
Okay, yes.
For tomorrow.
I open my offended. Yes. Make it quick.
May I please, Your Lordship, I beg to mention item number 21, Your Lordship.
20?
21. That this matter be taken after 2 weeks, Your Lordship. In this matter, we are to opt in instruction, Your Lordship. We need to opt in instruction. No objection.
No objection. No private respondents.
The government of Assam is there, Your Lordship, in this matter.
2 weeks now. Yes.
Obliged, Lordship.
May it please, Lordship. Lordship, I beg to mention item 18, Lordship.
Number?
18, Lordship. Lordship, I humbly pray for 2 weeks' time, Lordship.
Where's Mr. Charisu? He's not here.
He's here, Lordship, but we require some
Yes.
time, Lordship.
And
No
how?
objection, Your Lordship.
2 weeks. Yes.
Highly obliged, Lordship.
May I please, Your Lordship. Lordship, I beg to mention item number 17.
17?
Your Lordship.
Where's Mr. Sheikh?
He's there in another court.
I'm
Yeah.
for the respondent, Your Lordship. No objection, Your Lordship.
Yes. 2 weeks, yes.
Highly obliged, Your Lordship.
Supplementary list, item number 1.
You got a copy of the writ petition? Yes, what do you have to say?
My lord,
If the matters are interconnected,
the matter is in fact the
We are opposing, just 1 minute. We are opposing their managing committee, my lord, approval of their managing committee. They have come before this honorable court for a direction to the government to approve their managing committee, my lord. My lord, I'll just place the rules, my lord, how the managing committee of the is to be constituted, my lord.
Lordship, I may be allowed to say a few words.
Of course.
Because the writ petition is premature. What they have challenged in the writ petition is the meeting held, general body meeting held, thereafter the meeting of the steering committee. Because the director has yet to take any decisions, has not taken decision as yet. Because the writ will lie against the decision of the director. Writ will not lie against the challenging the how the
Constitutional Steering Committee,
committee, yes.
or the minutes of steering committee. You don't have the minutes of steering committee.
Steering committee.
Which
They
is
have annexed,
including.
my lord. In their writ petition, they have annexed.
Now my case is that the director has to take a decision.
Can I just complete?
Yes.
My lord, I'll place the rules, my lord. The governing rules, my lord.
Yes.
My lord, your lordship comes to rule 3, my lord.
Yes.
Rule 3, my lord.
Yes.
It says, save in case where the secretary to the government of Assam in the education department sanctions a special body under special circumstances, each governing body shall consist of the following members, namely 1 president, 1 secretary, 2 representatives of the teaching staff to be elected annually from amongst themselves, 2 persons to be nominated by the Guwahati University, in our case will be Nehu, my lord. Donors nominee, clause 6 is very important, my lord. 5 persons to be nominated by the government of whom 1 shall be a lady, 2 persons other than the members of the teaching staff to be co-opted by other members of whom 1 shall be a guardian, vice principal, ex officio. Now clause B, my lord. The president shall be nominated by the government from members nominated under clause A, Roman 6, my lord.
Okay.
What they do, my lord,
Yes.
Lordship kindly turns to their writ petition, my lord.
Who's the paying for the state? Yes.
It's 17 of the writ petition, my lord.
Page
Page 17, my lord.
17. Yes.
This is what they propose, my lord. Mr. Dr. M.R. Kaji, MLA, President, Abdul so-and-so, so-and-so. There are no government nominees, my lord. I pointed out 5 members are to be nominated by the government, my lord. The President is to be nominated by the government from clause 6, my lord. What they do, my lord, they sit one fine day, some purported steering committee, my lord, and they send the names to the government, my lord.
Yes, state.
My lord, this is a time to stop these things, my lord.
Who is this Dr. M.R. Kazi?
He is a MLA, my lord.
I'm representing.
You're the one.
Yes.
So you want to have it your way.
No, Lordship. The writ petition file. First, the writ petition file.
Let's see writ petition. Let's see a prayer writ petition. Yes.
So my prayer, Lordship, in this case, my writ petitions, I wanted the approval to be given by the directors. Director said there is a claim and counterclaim by both the parties, and subsequently the writ petition also filed. The person has got no locus standi, but it is still he filed. Now the director has to take a decision. So Lordship, the rule cited by my learned senior, I mean the director can take into account the rules and the.
Of course,
claim
no,
and counterclaim.
everything is done in accordance with law. Apart from that, why have you, if you're aware of the rules, why have you proposed this kind of governing body? You must be aware if you're running, if you're going to be, you're aware, correct?
Because this
Then how can you come to a decision where you have sat, and said like this should be the member, if when the statute or the rules provide otherwise? So do you think you start with a dead duck only? You're giving a dead duck for approval?
That is the Lordship we are saying that the director has not said anything.
No,
taken a decision.
but how even the prima facie looking at it, that means that your governing body cannot be approved.
But the director has to.
Where's the Nehu representative?
New representative is here, Lordship.
In the governing body? In your page 17?
Page 18, answer B.
14 and 15, my lord, they have set new representative.
New representative is there.
If I may, my lord.
Yes.
My lord, if my lord may come to the writ petition, paragraph
writ petition?
2, writ petition number 287.
Right?
Paragraph 2, that after the expiry of the tenure of the governing body of so-and-so, a general meeting was held on 16th May, wherein a steering committee was formed.
Yes.
Now, firstly, this is not on record. They have filed the steering committee resolution constituting the governing body, but not the one that constitutes the steering committee. Whereas, if my lord would come to page 17 of our reply,
Yes.
we have received there was no forwarding letter along with it. If my lord may have the reply.
1 second.
My lord.
(16)
17
Yes.
Annexure 8.3. My lord.
17?
Of our reply, my lord.
Page 17 is a list of signatures.
My lord, so this says a general meeting is held on 23rd July at so-and-so to constitute a steering committee. Now this we have received without a forwarding letter. So now we need to examine this. And then we have also received representation from purported parents, teachers. We have received counter, and then we have
Who's running the college now?
At present, there is no governing body.
How long has there been no governing body?
The tenure of the governing body is 3 years.
No, how long has there been no governing body in place? When did this old governing body term expire?
My lord, that lordship will find it my writ petition, my lord. Page
Okay, 1 second. Just give me the date. I will not be flipping pages like up, down. And yes. Yes. Last governing body when? When?
What is the date? 21 or 22? From 13th January 22, there is no managing committee. No
From
governing-
13?
January 22.
From 3rd January 22, there's been no governing body. And how's the college running?
Without governing body.
Then who makes the decisions?
No one is there.
My lord, that is again incorrect, my lord. In spite of withdrawal of the approval of the previous managing committee on 30th January 22, my lord, this Dr. M.R. Kaji is still signing as secretary, my lord. The next page of merit petition. This is a total mess, my lord.
Yes. Okay.
In para 6, I have stated these facts.
Yes. Take down.
Para 6, I have stated about the.
Yes.
Para 6, I have stated about the withdrawal of the approval.
Then why is he signing?
That I have no idea about whether signing or not signing. But that is the new committee is already proposed, have submitted to the directors,
Yes.
to the NEHU.
One is the WPC number 287/2023, and the next is WPC number 326/2023. These two writ petitions, wherein the core issue is with regard to the constitutional governing body of the, what is this?
Qazi and
Governing body
Zaman
of Qazi
And Jaman
and Zaman College.
White body.
College, is Badbari.
White body.
You have to pardon the sniffing, I'm carrying a cold. Here. Problem? Yes. Is being taken up together for disposal by this common order. Stop. Stop. Now the tenure of the last governing body of the said college, as per the pleadings, expired on 13 January 2022 and on 16 May 2023. It is noted that a general meeting was held wherein a steering committee was formed wherein purportedly the members of the governing body of Qazi and Zaman College were selected. As contended by the petitioner in WPC 287 in the first writ petition, pursuant to this decision of the steering committee, the principal of the college was instructed to approach the concerned authority to obtain approval However, as the approval, as a set approval as submitted was kept pending by the respondents, the WPC 287/2023 was filed by the writ petitioner one Shri Hidayatullah Qazi. In 326 2023, who is the writ petitioner here?
Well, he is one of the founders of the college.
The writ petitioner is stated to be
Son of the founder, my lord.
One of the founder members of the college. 226. 226. Okay. Yes. Tom, has, however, impugned the proceedings of the steering committee meeting held on 16/5/2023, wherein resolution was taken for constitution of the fresh governing body of Qazi and Zaman College. Stop. The grievance in the second petition is based on the contention that the writ petitioner in the earlier petition had been running the college without a governing body, and further, by the resolution of the steering committee, had self-proclaimed himself as the president. Stop. As such, directions have been prayed for constitution of a governing body, or fresh governing body, in accordance with law. Stop. Next paragraph. I've heard the counsels for the parties in both writ petitions. Stop. From the pleadings and from the materials, it appears that the approval is yet to be granted by who is respondent?
Number 2.
By respondent number 2. And from the affidavit filed, where is the affidavit? And from the affidavit filed? Yes, where do you see this under examination? You say that in your affidavit? Where do you say that?
Examination.
Yes or no? Decision. In view of the situation.
In paragraph number 12, they said they are taking decision.
Yes, a situation pertaining in the college wherein contradicting claims and counterclaims have been made. It is further averred in the said affidavit that the matter is still under consideration. Stop. Taking into consideration the facts and circumstances of the case, and also the stipulation of the rules, namely the Assam Area College Management Rule 976 as adopted, wherein at para 3 it has been given as follows, comma, it is expected that in the consideration of the claims or counterclaims or any prayer for approval any management committee, the same should be kept in mind, and approval of such should be in accordance with law. Both writ petitions seemingly being premature,
Some time frame maybe.
being premature,
My lord,
are disposed of.
what is praying, my lord, is
Yes.
instead of fresh election could be directed, my lord.
Directly
No,
take a decision.
in accordance with law, you have to take a decision. Both writ petitions are premature. He can't ask for a mandamus to say approve my management committee,
My lord,
and you also cannot come and say that
My lord, why my-
decision is impugning it.
Why, my lord? Because rules say, my lord, there is a
Yes, hear order, yes, please.
government nominees. my lord.
Please, yes, no. Yeah. As adopted. Yeah. With regard to the approval of any governing body for the college, comma, the respondent to shall keep in mind, shall dispose the same in accordance with law, and take such steps in furtherance thereof. Stop. Next paragraph. Till such time, the management of the college shall be under the who shall look after it. Who is the person who is competent to look after the management of the college?
I need to take
So that the students don't suffer.
need to take
Very good. Then you can destroy everything.
Director, my lord.
Empty out the coffers
In the meantime, somebody should.
and whistle all the way through the jungle. Yeah.
Director, my lord, through his.
The Director of Higher and Technical Education shall look after the affairs of the college. Yes. It is expected that next paragraph, entire exercise shall be completed in a period of 3 months from today. Both matters stand going to dispose of. With the above direction, both matters stand going to dispose of. Both of you coming with half-baked petitions.
Main list, item number 1.
For another 2 weeks time, you have written instruction also. Because of this session, I could not.
Because of?
Because of this session, I could not get the.
Why you have to get instructions from MLA?
Only 2 weeks time also.
You have to get instructions from MLA or something. Then?
But they were busy with the last week.
Mr. SJ pays for allowed for the 2 weeks time to obtain necessary instructions. This thereafter and so and so.
Item number 2.
Regarding wine store.
Yes, also.
Yes, Your Worship. Item number 2.
My lord, here I would like to file one small affidavit, my lord, to bring
Why?
on record one.
It's for admission hearing today.
My lord, to bring on record one affidavit, one notification, my lord. That is important.
This is the first appeal, Mr. Simkang. What affidavit you'll file?
My lord, one notification.
Was it before the trial court?
This is regarding this contingency charges, my lord. That is earlier notification, my lord. That was not part. That is not part
It's
of
not part of the records, correct? Then how will the court examine that?
Yes. My lord, I would pray, my lord, any other date maybe kindly.
Yes, Mr. Gautam. How can he bring the down?
Wants to do is, my lord, he's relying on a notification, latest notification. Now, this case pertains to the old act. So whether there is a new the old notification is there or not, that is which.
Was only to decide the matter, not then you can bring it.
My lord.
Mr. N. Singh can place some accommodation stop. He also placing allowed to bring a notification dated. Dated
29th March 1975.
Dated
29th March 1975.
To bring notice of the court for the purpose of proper adjudication. So he has allowed this up to 2 weeks. Yes.
Alright. Item number 3.
What happens? So resolved.
So item number 4 has been resolved. The parties have entered an agreement. They've vacated the property.
So what about this one?
Number 3, my lord, we were quite.
Follow likewise.
Yes, we were agreeable to. So we met the petitioner here has gone and met the MD also, and then as advised by the MD, he met others concerned, and then he was told to tie up with the petitioners in this other writ petition. So when he met them, they said that we ourselves don't have accommodation, from where to accommodate you. So
tie up means to agree to shift. Tie up means not that the Paul's client will give you a room.
On principle, on principle, he agrees to this effort at compromise. But then something should be there. How to compromise?
You make a special arrangement for him.
They have to meet the MD. They've not had any fruitful meetings. That's the only thing. As far as the others are concerned, the item number 4, they've settled. And they've already vacated the premises.
If we are given an opportunity and if our matter is considered and some...
What business does he run? This petitioner and
restaurant.
As of now, it's a restaurant.
Number 3?
Restaurant.
Restaurant.
In fact, Miller, this is just at that spot only where everyone is being accommodated. So anyway, Miller, that in the merits, I should not go into the merits. But yeah, but we are open. We if some effort is given, then we come
in the other connected matter, that is WPC number 262 of 2023. The parties have arrived at a settlement. Stop a comma, but however, with regard to innocent petitioner, it seems the process is still underway. Stop. In his view, the matter, this is a matter for 2 weeks. It is expected by then the matter should be resolved.
No, but, the second item with Mr. Paul, that is already over.
I'm talking about item number 3.
Alright.
So that will be disposed of. That the other one will be disposed of.
Yes. Now number 4.
Number 4. They filed an affidavit as well, bringing the agreement on record.
Pursuant to this agreement, my lords, there was an arrangement that some of the parties would hand over the possession by the 26th of September. That has been done, my lords. As a matter of fact, they've acknowledged that we have vacated.
So nothing survives.
Yes, the parties by an agreement dated 11 September 2023 have arrived at a settlement. The same has been placed by way of an affidavit and is annexure 1. By the respondent number.
We will close the PP proceedings as against you.
Annexure 1 stop.
Number 17.
In view of this settlement, nothing survives consideration. And
if Lordship will kindly have that agreement, clause 17 at page 12.
Will not interpret the agreement.
No, what we are only requesting, my lords, that the
there is
PP
one
proceedings.
little issue there, that pursuant to, my lords, this settlement happening, that there is a PPA proceeding, because this emanates out of the PPA
What happened to PPA proceeding? You dropped
that they will have to
Only
drop
as against the petitioners here, the 26 petitioners. It will go on as against the rest of them.
Yes,
I am only qua the petitioners.
yes, sir. Point number 1, that is the next that, annexure 1. Yes. Yes, no, stop there. It has been brought to notice of the court by the parties that in view of this settlement, the public premises, the proceedings under the Meghalaya Public Premises bracket Eviction of Unauthorized Occupants Act 1983, which are pending, will also be closed.
Can you record that as against the petitioners?
Yes, we close against the petitioners in the present petition. Next paragraph, as there nothing survives further for consideration, the said petition stands closed and disposed of.
Item number 5.
My lord, conducting counsel is from Guwahati, my lord, he is not well.
Doesn't matter. What is the instructions?
Lordship, we are yet to receive any instructions on receipt of this document from the petitioner's lordship. We have sought instructions.
What documents?
This document pertaining to a letter from the AH veteran.
Is it here? Before?
It's here, my lord. I have a copy of that. We're yet to receive instructions on the same.
No, the petitioner gave it to you.
The petitioner.
Who supplied a copy to you?
Last time they have submitted to the court one. Petitioner gave it to us, my lord.
Is that correct?
My lord, I have no knowledge, my lord, because I am not handling this matter, my lord. I would like to...
Yes, yes. They've submitted a copy to this court also, my lord.
Come on.
Submitted on the last date, that's reflected in the order also.
Oh yes, the Manjunatha CFS, the 6th September 2023. Mr. N. Sinkan praises the matter became of 2 weeks as the conducting counsel where the petitioner
is. Fix on 16 or 17
in this post. This is the matter on 17th October.
Oblige.
Item number 6.
Your Lordship's items 6 and 7 are similar. If your Lordship would kindly take up item 7 as the...
7 is...
it's the election petition which has been substantially heard.
Yes, the report was called for. Report was called for from the registry.
Yes, registry says that it was present for the stamp reporter.
Lordship, well...
Yes.
Sir, my lord, and in this regard, I also would like to submit another one more law point, my lord, in this item number 7. So just I would like to
Lordship, item number 6, I may kindly be heard after my senior man.
You are seeking adjournment?
No, I may be heard because I'm yet to make my submissions in number 6.
You're for the return candidate?
For the petitioner, my lord.
For the petitioner. Now, who's appealing for return candidate in item number
6?
Your Lordships, I am. For the respondent number 3 in item 6.
He's return candidate.
Please, Your Lordships.
Okay. Yes.
Yeah. Bring those things.
Where were we?
Your
This
Lordship,
matter?
it was at the stage of rejoinder argument.
Yes, because
yeah,
the arguments in opposition had been heard, and I was to rejoin on those aspects. Which
only one point. Just I would like to add, my lord, before starting my friend's argument. May I refer to one judgment?
I am. Benar setengah ni 14, 11, 8, 15 sudah 11, 8 kayaknya apa itu 14, 15 just one second. This seems my notes of the last hearing have been itu nanti dapat tentang 14, 9, 23 lah, 14 or 15 kan dapat last hearing. Okay, never mind.
Yes. Pair number. Yeah, I'll give you after. I'll give you.
Yes.
So, my lord, pair number 5 of the judgment, my lord, which I referred, my lord. Merit, my lord. In the written argument, the Land Council has made a wrong reference of the Article 349B of the Constitution of India. In fact, it ought to have been Article 329B, as referred to subsequently. Article 329B of the Constitution of India reads as under. Article 329B, bar to interference by courts in electoral matters, notwithstanding anything in this Constitution, no election to either House of the Parliament or to the House of either of the House of the Legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for or by or under any law met by the appropriate legislature. Article 225 of the Constitution of India Article 225, jurisdiction of the existing High Court subject to the provisions of the Constitution and to the provisions of any law of the appropriate legislature made by virtue of the powers conferred on that legislature by this Constitution at the jurisdiction of and the law administered in any existing High Court and the respective powers of the judges thereof in relation to the administration of justice of the court, including any power to make rules of court and to regulate the sittings of the court and of the members thereof sitting alone or in division court, shall be the same as immediately before the commencement of this Constitution, provided that any restriction to which the exercise of the original jurisdiction by any of the High Court with respect to any matter concerning the revenue or concerning any act, order or done in the collection thereof was subject immediately before the commencement of the Constitution shall no longer apply in the exercise of such jurisdiction. Section 46 of the Rajasthan High Court order, these are the regulation, my lord. Regulation, just I am coming to that in the bottom. Section 81 clause 1 of the Act stood as such and has not been amended consequent upon the repealing Section 81 clause 2. The only change brought in the respect of the forum, that is the High Court and the petition period of limitation and about the mode of representation, no change has been made except repeating the deeming provision. In case Section 81 is a paraphrase and only relevant words for the purpose of the application are read, then Section 81(1) of the Act reads as under. An election petition may be presented on one or more grounds to the High Court by any candidate at such election or any elector. Next page. The word presented in the aforesaid paraphrasing enables any candidate or the elector to challenge the election petition by an election petition and no other person. Therefore, call in question the election. The main controversy between the parties is on the word presented, whether the word presented used in section 81(1) of the Act means presented in person or presented by any candidate or any elector. The word presented used here is as a verb, and what is the verbatical meaning of it has to be considered. The word presented goes with election petition and qualifies the person on whose behalf the election petition can be presented. If the words by any candidate at any such election or any election elector are not interpreted as on behalf of the candidate or an elector, then there may be circumstances where great hardships can be caused. For example, a candidate or an elector who has been defeated and has suffered a heart attack or such disablement which prevents him from moving out of the bed and his town is away from seat of the High Court, then he cannot challenge the election through he very much wants to do it. Webster in his Three International Dictionary has mentioned the meaning of the word by. It means in proximity to, long or through, during the course of, through the means of, as instrumentality of, in conformity or harmony with, on behalf of, so long and so forth. Therefore, on behalf of is one of the meaning.
One thing, Mr.
Yes,
is that now is this judgment dealing with the specific rules of the High Court or the general proposition as given?
General proposition also there, in the rules also there. At the same time, general proposition.
No, but does the rule allow that? You know that it
rule
can,
allows.
It makes exception that you can presume anybody.
Yes, my lord.
Okay.
Yes, my lord. So to that, my lord, just I am referring to the penal number. This thing, my lord, in the bottom, because there is a Hindi version, because that has been interpreted here. Also supports in the interpretation which I have given above. It is
here. Yes.
Yes. A matter that Rajasthan High Court or under the powers conferred on it by section 46 of the ordinance and article 225 of the Constitution of India frame rules about dealing with election petition, and their rule 4 has been enacted. A perusal of the rule 4 makes it quite clear that it can be presented either in person or by an advocate duly authorized in this behalf by the party concerned. Earlier, when the petition used to be presented before the tribunal, section 81(2) of the Act was on the statute where deeming provision had been given so as to remove the ambiguity of the doubts, but it was repeated subsequently. Still, in my opinion, the word by in section 81(1) cannot be given a limited meaning so as to make the presentation by the candidate or the elector in person only. In Ram Haris Mishra, Sukan Raj Singh Supra, it has been held as under the Baklanama in favor of the advocate is worded as general terms so as to give him all possible authority for the conduct of the election case, including the filing of any paper. The expression filing of any paper, in my opinion, includes the presentation election petition also. In any case of the facts as found above, the petition was handed over to the bench secretary of the court under the direction of the court by advocate of the petitioner in the immediate presence of the petitioner, and the presentation would be quite valid in view of the Supreme Court's decision referred to above. The issue is decided in the negative. In Nedu Murali Janardhan Reddy versus YC Rangareddy Supra, it has been held as under there is nothing in the Representation of the People Act 1951 which lays down a different procedure for the presentation of the election petition than the one prescribed by the Code of Civil Procedure for presentation of the plans. The election petition having been duly signed and verified by the petitioner and being accompanied by the requisite number of the copies and affidavits and its security for deposit, of course, satisfies all the requirements of section 80 and 81 of the Representation of the People's Act, and having been presented by the advocate or the petitioner must be deemed to have been presented in accordance with law. In Lal Bahadur Singh versus Vishal Singh Supra, it has been held as under the UP town areas conduct of the election chairman rules 1953. A question arose in Ganpat Singh's case whether the personal presentation of an election petition of the petitioner was necessary under Rule 47. The question was answered in the negative. The provision of clause 2 of the R 24 relevant portion of the 47 which election petition will be presented by only those persons who were interpreting this rule. It was laid down that, in our opinion, that there is no sufficient ground for placing this restricted interpretation on this sub-rule. We think that primary object sub-rule 1, Rule 47 is to define and thereby limit the class of person who can challenge an election. Its purpose is to make clear that the validity of an election can be questioned only by a candidate at that election whose name is on a certain list or whose nomination paper has been rejected. It does not, in our view, prescribe the manner in which the election petition is to be presented unless there is something in an enactment which shows that a certain act must be performed by the particular person, or the nature of the act itself says that it can be performed only by that person. That act can ordinarily be done by a duly authorized agent. If it had been the intention that the petitioner must personally present his election petition, it would have been a very simple matter for the rule-making authority to make provision to that effect and so put the matter beyond doubt, as it has been done. For example, in CI 36 of the UP Municipalities Conduct Election Rules presented election petition rules 1955, where it is expressly provided that an election petition shall be presented in person by the petitioner, or if there are more than one petitioner by any one or more than that has not been done. And we do not consider that Order 47 requires that petitioner to present his petition in person. Such a construction may result in a petitioner who is cited by accident or illness from presentation petition at all. For it is in a common ground that provision of the Indian Limitation Act have no application to the presentation of the petition under Town Area Act in the Ganpat so and so, in election tribunal so and so. It is difficult sometimes to distinguish between the irregularity and the nullity. But the safest rule of the determine what is irregularity and what is a nullity is to see whether the party can wipe that objection. If he can wipe it, it amounts to an irregularity, and if he cannot, it is a nullity. We think that there can be no doubt that it is open to the respondent if he so chooses to ignore that fact. The petition has to be present, not been presented by the petitioner in person. Thus, though on different approach, but similar view has been taken in the aforesaid cases, and election petition cannot be dismissed on the technicality matter. Because here in this case, in the Lordship judgment also, paragraph number 11, it is clearly said that because as the defect, therefore, being a mere technical nature, it cannot be held that fatal and amend election petition, and observe earlier that there is a substantial compliance. That means election petition should not be dismissed on this technical ground, mere technical ground. And the paragraph number 6 also on the following matter. In the paragraph number 7, I am coming to that, paragraph number 7 in the last. Another argument of the Learned Counsel for the respondent that letter of authority has not been presented along with the election petition. Sufficed is to say that Wakalanma file has been recited authorizing the Counsel Sri Rajendra Prasad Sharma who present the election petition. Besides this, Sri Rajendra Prasad advocate has filed before the registrar along with the petition in the letter written by himself, his own handwriting, stating that he has been duly authorized by the Bhanuwar Singh, son of the Nahar Singh Rajput, resident of the Naulagar district, Jhunjhun, to present the election petition before this honorable court. This has been filed along with the election petition before the registrar, and in my opinion, it is sufficient compliance with Rule 4. As a matter of aforesaid discussion, the application filed by the respondent have no force and are dismissed with cost, which I assess to be 300. The respondent is directed to return. So my lord, even they have been, in spite of dismissal, then they have directed to file a written statement, my lord. In this case also.
Yes.
That is the judgment which I have relied upon. And paragraph number 11 of the Lordship judgment, because I am relying. Because this is mere technical ground, matter cannot be dismissed, my lord.
But that earlier miscase is only on one point.
Yes, my lord.
It doesn't cover the entire objection that
no, my lord, here in this case also, the registry, as per the registry's report, my lord, if it is so complied with, everything is complied with, then there is no question of, dismissal of the election petition on this ground, my lord.
Only it's present on stamp report, but who presented it? That's the only thing.
Yes, ma'am.
Yes, Mr. Sai.
Yes. Your Lordship, there were briefly two arguments that were canvassed by the election petitioner in response to my application. The first argument was that there exists a valid cause of action for filing the election petition. At the outset, Lordship, I dispute the fact that there exists any valid cause of action, and I reserve the right to file my response on that written statement if and when the time so arrives. But existence of a valid cause of action is not the issue that is germane before your Lordship. The second issue that was argued before your lordship is that these are technical errors of a technical nature and therefore they are not fundamentally fatal to the election petition. Inherent in the second proposition that has been canvassed by the election petitioner is a concession. There lies an admission that there is in fact a defect in the election petition, and that defect
in your submission cannot be cured.
Yes, in their understanding it can be cured, it's a curable defect.
Yes.
And in our respectful submission, as the law would show and the express provisions of the Representation of People's Act and in fact the Constitution of India would show, these are not curable defects, these are fundamentally fatal, and the rules of this Honorable High Court, which have been interpreted by the Honorable Guwahati High Court and have been implemented with approval by the Honorable Supreme Court also, have been held as requiring, one, not only a personal presence of the election petitioner, but also the personal presence before the stamp reporter, then also that the stamp reporter must make an endorsement with the date, time, particulars of the person who's presenting it before him for an election petition to be validly presented.
Okay.
Your Lordship, my application was filed under Order 7, Rule 11, read with Section 86 of the Representation of People's Act.
Yes.
Under Order 7, Rule 11, Lordship, I have invoked point number D. If your Lordship takes Order 7, Rule 11, which is that the plaint is barred by law. Rejection of plaint. The plaint shall be rejected in the following cases. D. Where the suit appears from the statement in the plaint to be barred by any law.
Yes.
It is my respectful submission that the plaint before your Lordship is barred by Section 86 of the Representation of People's Act. And it is barred on 2 counts. Lordship will have Section 86 now of the Representation of People's Act.
Yes.
86(1). Trial of election petitions. The High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or Section 82 or Section 117. Therefore, the onus is cast on the High Court to necessarily dismiss an election petition which is falling foul of Section 81, 82 or 117. Now, your Lordship, we have taken 2 pleas in our 711 application. The first plea is that the election petition has not been validly presented. That's number 1. And the second is that assuming there is a valid presentation, which there isn't for the sake of argument, then the form and contents of the election petition are also in violation with Section 81, which would necessarily attract Section 86.
Okay.
Your Lordship will now have Section 80 of the Representations of People's Act. Why both presentation and form have to be in accordance with the representation?
Section
80. No election shall be called into question.
Yes.
No election shall be called in question except by an election petition presented in accordance with the provisions of this part. The emphasis is on an election petition presented in accordance with the provisions of this part. Therefore, only that petition which is meeting the requirements of this part and is validly presented can at all be termed as an election petition. Your Lordship will also note that this is not a mere technicality, this is a substantive requirement of the law.
Yes.
Lordship will also find that 80A, High Court to try election petitions, The court having jurisdiction to try an election petition shall be the High Court.
Yes.
Lordship, this provision was included by an amendment in the year 1966. Prior thereto, the election petitions were tried by an election tribunal. But the High Court was substituted in place of the election tribunal. However, since it is acting in a statutory manner, the High Court shall not be functioning under its own inherent jurisdiction under Article 226 or otherwise, but shall be discharging a statutory function under the Election Representation of People's Act. Now, Your Lordship, in the entirety of the petition, there is no assertion that there has been personal presentation of the election petition in accordance with the rules of the High Court.
Yes.
In this behalf, Your Lordship, I would just like to point out the relevant rules
of the High Court.
Before that, Lordship will just see section 81 while we're at the same page, section 81. Presentation of the petitions. An election petition calling in question any election may be presented on one or more of the grounds specified in subsection 1 of section 100 and section 101 to the High Court by any candidate at such election or any elector within 45 days from but not earlier than the date of election of the returned candidate, or if there are more than one returned candidate at election and dates of their election are different, the later of those two dates. Again, under in section 81(1), Lordship, the references may be presented. Presentation of the election petition is something that is fundamental even under section 81, and therefore that presentation must be that in person.
Yes.
It may be presented on one or more grounds by any candidate. By any candidate at such election or any elector. So the presentation is by any candidate or by an elector.
Yes.
And the limitation period is 45 days. So the statute on a plain reading itself requires the presentation to be that which is by the elector or by a candidate in the election. Now Lordship will find section 81(3). Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such
And they had filed earlier to correct this.
Yes, Your Lordship.
That is,
so again, the issue why I am raising 81(3) is also that Lordship has permitted the filing of
supplying
additional
excessive copies. Yes.
But the question today is that now when the 711 application has is being heard, whether Your Lordship has condoned the defect or not.
Whether the judgment will cover this situation also.
Yes, whether the judgment which is on 11th August
is
a condonation of a defect under 81(3).
Okay.
And it is my respectful submission, Your Lordship, that Lordship has not condoned by grant of mere permission to file extra copies without looking into the legal consequences thereof.
Yes.
That is not a condonation of the requirement under 81(3), and in fact in my respectful submission there can be no condonation of a requirement under 81(3).
Right, okay.
Now Your Lordship will have page 26 of my application under 711, which is the miss case 19.
Yes.
Page 26.
Page 26.
Yes. 26.
The GHC rules.
The Guwahati High Court.
Yes.
Because the judgment that was read out by my learned senior at the last occasion, that is a judgment which in fact...
Which judgment?
The judgment read out
Just now.
today itself, yes.
It's from
that
Rajasthan.
judgment was concerning Rajasthan High Court
Rules.
and the Rajasthan High Court rules permitted a petition to be filed by a person either in person or by a person duly authorized.
Right.
It is my respectful submission that the Guwahati High Court rules do not permit that.
Yes.
And that in fact has been held as such by the Honorable High Court and then affirmed by the Honorable Supreme Court. The rules are at page 26.
Yeah.
An election petition under section 80A of the Representations of People's Act may be presented duly verified in the form prescribed under section 82 and 83 of the said Act before the stamp reporter of this court with a court fee of ₹6 affixed thereon within 45 days from the date of election of the returned candidate, or if there are more than one returned candidate at the election and the dates of their election are different, the latter of the two dates.
Yes.
Every such petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, together with one extra copy, all the copies being fully attested by the petitioner under his own signature to be a true copy of the petition, and as many envelopes as there are respondents hearing requisite postage stamp to enable service to be effected by the registered post.
Yeah.
Now your lordship will find that both the provisions are talking about presentation, and number two, they are also talking about personal attestation of every copy of the petition.
Yes.
In the first instance, they are talking about presentation before the stamp reporter.
Yes. Yes.
There is nothing that has been brought on record, your lordship, to indicate that these two requirements have in fact been met in the facts of the present case. Now your lordship will come over the page 2. Now why that presentation has to be in person is clear from provision number 2, rule 2. As soon as possible, the petition or petitions which is or are in time and in form shall be laid before the judge or judges assigned by the Honorable Chief Justice from time to time for the trial of election petitions under subsection 2 of section 80A of the Representations of People's Act for registration and other orders, so that the petitions can be tried as expeditiously as possible in the manner laid down under Rule 86(7) of the aforesaid Act. Now again under Rule 2, only two kinds of petitions can be...
Yes, sorry.
Only two kinds of petitions can be forwarded to the concerned election judge, which is one, the petition which is in time,
Yes.
and the second, the petition which is in form.
Yes.
Now, so far as the requirement of form is concerned, your lordship, as I have read out to your lordship, a petition which is filed must meet the requirements of 81(3),
Yes.
which is that there must be sufficient number of copies, there must be personal attestation of each page, each copy must be identical, and it is only those petitions that can be forwarded to the concerned election judge. In the present case, by not presenting it personally before the stamp reporter, this opportunity could not have been availed. This examination has not been carried out.
Okay.
And therefore there is a violation of Rule 2 of the Guwahati High Court rules,
Yes.
which apply to this honorable court. 1 and 2, both.
Yes.
Now your lordship, so far as these rules are concerned, your lordship will find the judgment of the Honorable High Court of Guwahati, which has interpreted these rules. That is at page 42.
Okay, compilation.
Of the application itself. I have annexed it with the application itself.
Anwara Taimur.
Yes, Abdul Jabbar.
42.
Is 40?
Yes. Yes.
Lordship will find the facts at paragraph 2. The notice of the election petition, the facts are somewhat relevant to
Para 2.
Yes.
After the head
Two at
notes.
page 45.
Okay, yes. The notice of the election petition.
Yes. The notice of the election petition has been served on each of the respondents, and the respondent, Saida Anwara Taimur, has filed an application for dismissal of the petition under section 86(1) for the Representation of People's Act, stating that the election petition was not presented in the manner and method prescribed for the presentation of an election petition under section 80, 80A and 81 of the Act, and the conduct of election rules 1961, that the rule 1 of chapter 8A of the rules of Guwahati High Court, which provides that an election petition may be presented to the stamp reporter of the High Court, is violative of sections 80, 81, 80A and 81 of the Act, and rule of chapter 8A of the Guwahati High Court rules is arbitrary, illegal, null and void. That the election petition was not presented or filed by the petitioner in person.
So, but one thing, Mrs. Sai, just to, if I recall, now the counter submission made by the counsel for the election petitioners that yes, okay, fine, the presentation was, but that was taken up as a preliminary issue when the issues were framed. Is that correct? That is what I mean, if I recollect, because yes, we are because we've travelled this road before.
In fact,
with regard, yes, it was not taken at the at the threshold. I mean, this consideration was taken as one of the issues when the issues were framed by the.
That is why at the outset I flagged that the two contentions they have argued is one, that they have valid cause of action, and two, that if even otherwise.
No, there's nothing they can stop. No, there's nothing.
This is a case of evidence.
No, this is only that you have satisfied this code that this should be, it should be done at threshold,
Yes.
and not that it doesn't have to go to the frame or other issues.
Now, why yes. At the threshold on the basis of these documents alone, your lordship must in fact allow the 711 application and not call for evidence, is because the requirement of the law, so far as endorsement,
have not been met,
is also set out. How the stamp reporter has to in fact receive the election petition is set out in at least 3 judgments. 2 judgments of the Supreme Court and this judgment that I am reading out to your lordship. 3 judgments have held that the receipt of the election petition by the stamp reporter must necessarily involve putting in the date, time, initials, name of the person from whom it is received. In the entirety of the petition, page by page I have examined it, there is no such endorsement.
Right.
Once on the face of the record, there is nothing to indicate. Evidence would be led on pleadings. There has to be some semblance of pleadings, there has to be some semblance of material on which evidence will eventually be led. If there are no pleadings or there are no material to even indicate, for a moment, sir. There are no material to indicate even at the threshold, an iota of material, then there will be no requirement for evidence. That is my respectful submission for your lordship's kind.
Yes, that's what, you have to satisfy those code in that point, that this point that we reached 711, it has been taken at threshold. We do not need to travel beyond to business statements and filing of issues and filing of suggested issues.
I will show that the judgments of the Honorable Supreme Court are ones in which the High Court has rejected the election petition at the threshold.
Okay, yes.
At the threshold. The judgments that I am citing are the ones that have received dismissal at the threshold.
Right.
Now, your lordship will find somewhere in the bottom of para 2, there is.
Yes. That's point number 1 that further stated.
It is also stated that the filing register shows that there was no filing was recorded on 8th April 1983. And although the records of the present election petition shows that the affidavit of the election petitioner was sworn and he was identified on the 8th April 1983 at 1 p.m. and it bears the seal of the High Court dated 8th April 1983, but this position is not correct in view of the facts stated above. The respondent 1 has further stated that the filing section remained closed at the relevant time, namely at 1 p.m. on 8th April 1983, and the report of the stamp reporter was made on 11th April 1983, but the filing register records the filing of the election petition only as on 13th April 1983, while tender number so and so, and filing register does not show that the election petition was presented on 8th April 1983, and therefore election petition is barred by limitation under section 81 of the Act. Lordship, I'll just pause here for a moment. in this case, there are such facts that could perhaps have warranted requirement of evidence.
Yes.
But in our case, there is only one sentence. In the face of a specific allegation that this has not been done in accordance with law, in the face of 2-3 judgments which we have annexed with our 711, that this has not been done.
So without
without
evidence, it can be settled. You mean?
Yes, because there is a ball deferment in response to that. There is no. If once faced with the assertion in the 711 application that this has not been done, a prudent litigant would then indicate with very many particulars exactly as to how it has been done. That on this day I went.
Or seem to have been done.
This has not been done. That averment is not at all there.
Right.
So therefore there is no contest on this issue at all. In fact, even today, the judgment that was read out to your lordship was in fact an admission of the fact that there was no personal presence.
Yes.
And that in absence of personal presence, it can be dispensed with.
No, but that is unique to the High Court.
Yes, but
it has
the proposition of law that is
Yes.
being canvassed before your lordship today is that yes, I was not personally present and this court can do away with it since it's a technical requirement.
You're right. Let's come back in 2 minutes. 1 second.
Yes.
Yes, sorry. I'm carrying a very bad cold. So
because the Lordship seems to be suffering from cold.
Congestion. That's why.
Excellent.
So yes. Please.
Question to take place.
The Lordship will now have page 51
Of the judgment.
of the judgment.
Open it. No, that
Page
is
51 of the application. Para 10, that is issue number 4. Because this issue will be put to rest after this paragraph. Whether it is required to be personally presented or not. Issue number 4. By whom an election petition is to be presented. Mr. Lahiri has submitted that an election petition must be presented by the candidate himself, though the word himself or personally have not been incorporated in the body of section 81. Learned Counsel has drawn my attention to a decision of the Supreme Court in Shirdan Singh and another decision of the MP High Court in Raman Lal. In Shirdan Singh, the Supreme Court has held that an election petition presented by an advocate's clerk in the immediate presence of the candidate to the registrar of the High Court is in substance, though not in form, it was presented by the candidate himself. Full facts of the case are not in the judgment. However, the decision shows that if the clerk was not authorized to present the election petition, the presence of the candidate himself was valid presentation under section 81. Or if the clerk was authorized to present the petition under the High Court rule, the presence of the candidate implied that an election petition must be presented by the candidate himself. Be that as it may, the decision of the Supreme Court shows that presentation of an election petition is not a mere or idle formality.
right.
In Raman Lal, the Madhya Pradesh High Court has held that where the manner of presentation is prescribed in the election law, its scope cannot be extended or enlarged by importing into the provisions something from the general law. Therefore, the presentation of the election petition ought to have been made by the candidate himself. Although the words himself or personally have not been incorporated in the body of section 81, the intention of the legislature is clear. Is the view of the MP High Court correct? A reading of Article 329B, this is important, Your Lordship. A reading of Article 329B with sections 81, 82, 83 and 117 shows that the manner of presentation of an election petition is provided. In the series of cases of the Supreme Court referred to above, the Supreme Court has held that common law and equity are alien or foreign to election dispute, and that an act has furnished a complete code for challenging an election, and the election must be challenged in the manner provided under the act. Under section 81, the election petition may be presented by the candidate at an election. In A. Madan Mohan, Lordship, I'm skipping the judgment. The decision of the Supreme Court reveals that the word candidate is to be interpreted literally and strictly to promote the object of the act. As such, an advocate cannot be said to be a candidate under the act. In view of the discussion above, I respectfully agree with the conclusion reached by the MP High Court, and I hold that the election petition must be presented by the candidate himself. This is a decision of this Honorable Court, and therefore it would be binding in my respectful submission. And this has been quoted with approval in a subsequent decision of the Honorable Supreme Court as well. Now, Your Lordship will have for a moment page 38
Of your petition.
of the application itself. This is G.V. Sri Rama Reddy and another versus returning officer. I will demonstrate that in this judgment, Your Lordship, the High Court had at the threshold rejected the 711. So, to Your Lordship's query
Yes.
as to whether it can be done at the threshold without calling for
Evidence or framing issues. Yes.
this is an example of one such case. Your Lordship will find the facts at from the first 2-3 paragraphs are relevant to ascertain the facts, Your Lordship. I'll just read them out.
Yes.
This appeal under 116A of the Representation of Peoples Act 1951 is directed against the order dated 19/9/2008 of the High Court of Karnataka at Bangalore in election petition number so and so, and by which the High Court upheld the objection of the registry that there was no proper presentation of the election petition in terms of section 81(1) of the Representation of Peoples Act, and consequently dismissed the election petition. The election to constituency number 140 Begapalli Karnataka Legislative Assembly was, Lordship, this may not be relevant. Para 4.
Yes.
The appellants filed an election petition under section 81 of the Act on various grounds, pointing out large-scale irregularities and illegalities committed by the respondent authorities in the voting and illegalities of allowing recounting after announcing the declaration of appellant 1 as elected. On 6/7/2008, the first appellant through his advocate Shri Siva Reddy presented the election petition before Registrar Judicial High Court of Karnataka. The Registry of the High Court put up an office objection that as the appellant was not present at the time of filing of the election petition, the presentation of the papers was not in accordance with section 81 of the Act, and as such there was no proper filing of the election petition. Based on the office objection, the matter was placed before the learned single judge of the High Court dealing with the election petition, and arguments were heard. By the impugned order, the learned single judge, based on the recorded statement of the Registrar Judicial dated 7/7/2008, that the petitioners were not present while presenting this petition, and finding that it was not a proper presentation in terms of section 81, dismissed the election petition. Aggrieved by the said order, the appellants have filed this appeal before this honorable court, before this court. Para 7. Since the election petition was dismissed at the threshold on the alleged ground of improper filing, there is no need to traverse various averments made therein. The only question to be considered by this court is whether the election petition as presented was in accordance with section 81(1) of the Act, and whether the High Court was right in dismissing the same. Now your Lordship will find at paragraph 12 and 13 are the respective contentions of the parties. It was further contended by Mr. Ramasesh that the presentation of the election petition by a candidate or elector is not mandatory, and if it is presented by his advocate duly authorized, the same is proper presentation in terms of subsection 1 of section 81 of the Act. It was also contended that in cases of substantial compliance, and where it is shown that absence was not to harm the respondent's case and certain exigencies existed which made for presence difficult, the court should not dismiss the petition merely for non-compliance with section 81(1) of the Act. This is the exact submission before your Lordship. On the other hand, learned counsel appearing for the contesting second respondent, successful candidate, submitted that in view of the language used in subsection 1, it is mandatory that the candidate or elector is to be personally present before the High Court. In view of the endorsement by the Registrar Judicial stating that the petitioners were not present before the election, were not present while presenting the election petition, the impugned order of the High Court dismissing the same cannot be faulted. A close look at section 81 reveals that the two remaining subsections after the amendment introduced by Act 47 of 1966 deal with two distinct but interrelated issues. Subsection 1 deals with necessary requirements of any petition challenging an election, and subsection 3 deals with additional requirements as to the petition presented. Subsection 1 has 5 components. 1. The qualification of the petitioner, that is, she must be either a candidate at such election or an elector. 2. The petition must be presented by the petitioner. 3. The petition must be based on one or more of the grounds specified in subsection 1 of section 100 and section 101. It must be presented in the High Court. It must be presented within 45 days from, but not earlier than the date of the election of the returned candidate, or if there are more than one returned candidate at the election and dates of their election are different, the later of those 2 dates. Therefore, all these 5 requirements are extremely specific and clear. This inference is further strengthened by section 86(1), which provides that the High Court shall dismiss an election petition which does not comply with the provisions of section 81. Just pause here for a moment, your Lordship.
Yes.
Here it is quite clear that in the present case also, these submissions that have been made on behalf of the respondent election petitioner are exactly the same. It is that the petitioner's personal presence was not required. This is the exact contention that was raised before the Honorable.
No, he's produced a judgment also which.
Yes, I'm not denying, madam.
that. Okay, no, yes.
So
Let him finish.
Yes, yes.
So when there is an absence of a denial of the fact that the election petitioner was not present, in fact there is a concession that they were not present, then the only thing that is required to be seen, in my respectful submission, is whether or not that is in line with the requirements of the law. And as per para 14, it is violative of both 81 and section 86. Now your lordship will find paragraph 16.
Okay.
While interpreting a special statute, which is a self-contained code, the court must consider the intention of the legislature. The reason for this fidelity towards legislative intent is that the statute has been enacted with a specific purpose which must be measured from the wording of the statute strictly construed. The preamble of the Representation of People's Act makes it clear that for conduct of election of the Houses of the Parliament or legislature of each state, the qualification and disqualification from membership of those houses, the corrupt practice and other offences in connection with the allegations, the Act was enacted by the Parliament. In spite of existence of adequate provisions of the Code of Civil Procedure relating to institution of the suit, the Act contains elaborate provisions as to disputes regarding elections. It not only prescribes how election petitions are to be presented, but it also mandates what are the materials to be accompanied with the election petition, details regarding parties, contents of the same, relief that may be claimed in the petition. How trials of election petitions are to be conducted has been specifically provided in Chapter 3 of Part 6. In such circumstances, we are of the view that the provisions have to be interpreted as mentioned by the legislature. This is para 19 is important. One can discern the reason why the petition is required to be presented by the petitioner personally. An election petition is a serious matter with a variety of consequences. Since a petition may lead to vitiation of a democratic process, any procedure provided by an election statute must be read strictly. Therefore, the legislature has provided that the petition must be presented by the petitioner himself, so that at the time of presentation, the High Court may make a preliminary verification which ensures that the petition is neither frivolous nor vexatious. Now, Lordship, this will be connected with Rule 2 under the High Court rule, which says that only that which is in time and in form shall be forwarded to the concerned judge. So, preliminary scrutiny is also required. Now, Your Lordship, para 24.
Yes. Can you just give me the judgment cited today? Yes. Which is that judgment? Which they have cited today? Bawar Singh?
Yes.
Huh? Bawar Singh.
Now, Your Lordship, in fact, the judgment that has been quoted today by my learned senior has been considered in paragraph 22 of this judgment.
Yes.
Learned counsel appearing for the appellants relied upon a decision of the High Court of Rajasthan Jaipur bench in Bawar Singh versus Navrang Singh. In the case before the learned single judge, the election petition had been presented by one Rajendra Prasad advocate and not by the petitioner himself. It was argued by the learned counsel for the petitioner therein that the election petition had been validly presented under section 81(1) of the Act, because section 81(1) of the Act only makes a provision as to who can file an election petition and does not deal with as to who should actually present it before the registry. It is further submitted that section 81 of the Act nowhere provides that the petitioner should be physically present at the time of presentation of the election petition. The learned single judge, after adverting to the words by, presented, concluded that these words used in section 81(1) of the Act have to be given a wide meaning and found that the election petition filed through an advocate without the presence of candidate or elector is valid. We are unable to accept the said conclusion. We have already pointed out that in spite of the provisions in CPC and the Evidence Act relating to institution of the suit and recording of evidence, etc., This act provides all the details starting from the presentation of the election petition ending with the decision of the High Court. In such circumstances, it is but proper to interpret the language used by the legislature and implement the same accordingly. The challenge to an election is a serious matter. The object of presenting an election petition by a candidate or elector is to ensure the genuineness and to curtail vexatious litigations. If we consider subsection 1 along with other provisions in chapter 2 and 3, the object and intent of the legislature is that the provision, that is section 81(1), is to be strictly adhered and complied with. And para 25, Lordship, the view of the High Court has been upheld.
Yes.
So this judgment, Lordship, in my respect,
This approved the
every issue.
Jaipur judgment.
And it also covers the issue that a preliminary rejection of an election petition without calling for evidence can be done if it is apparent on the face of the record that there is no personal presentation. And it has approved, in fact, that view taken by the High Court in this regard.
Yes. You're saying that your submissions are based on the fact that we don't have to frame issue taken because it's an admitted fact.
Yes.
That they're not present.
Yes.
And the law commands such, so under 86 there's no way out, but the court's compelled by the statute to return, or not return, to dismiss election petition. Correct?
Correct.
Yes.
That is my, because in terms of...
There's some substance of submission.
Yes. For instance, Lordship, section 3 of the Limitation Act, it says that the court shall dismiss any petition which is presented beyond the period of limitation, even if limitation is not taken as a plea. So therefore, if a suit is filed beyond a period of 3 years, the onus under section 3 of the Limitation Act is that it shall be dismissed. So similarly, under section 86 also, the onus is cast upon the court to dismiss it. So therefore, if 81 is not met, the court shall under 86 dismiss the petition, is my respectful submission for your Lordship. And there are two circumstances which in fact show that there is no preliminary verification. There is first circumstance is that in this election petition, the Election Commission was made a party. It was subsequently deleted by an application. Second circumstance is that they made an application on their own seeking to correct certain defects.
That has been allowed.
So both these applications are evidence of the fact that there was no preliminary verification carried out by the High Court before placing the matter before your Lordship.
Yes.
Because it was not personally presented and properly presented in accordance with the rules.
Finished.
Finished.
Yes.
Some time. Now, your Lordship, so far as on the issue of why evidence should not be called for.
Why it should not be taken the preliminary issue out of framing of other issues?
Yes, Lordship, on that I just want to indicate what is the requirement of the law. The law says that the endorsement must be made in a specific manner. And if your Lordship finds that there is even a semblance of such an endorsement or there is a semblance of such an averment, then surely a preliminary issue may be required to be framed and evidence may be required to be led on that, and then the issue can be decided. But whether that preliminary threshold has been crossed or not,
okay, yes.
On that point, your Lordship, page 59, this is the judgment of Hukum Dev Narayan.
You annex all the judgments here on me.
It's an X.
59.
Yes. At page 62. At page 62 on the right hand side, your Lordship. This is paragraph number 8. A reading of the above rules would show that 1. The petition must first be presented to the stamp reporter. 2. The stamp reporter has to certify whether it is in time and in conformity with the Act and rules in that behalf or it is defective. And thereafter, the petition shall be returned to the petitioner for removing defects, if any, and for formal presentation after removing the defects. If the judge who is designated shall entertain and try the election petition is absent, the petition shall be presented before the bench hearing civil applications and motions. Now, Your Lordship, I have drawn attention to your to this aspect is that the receipt of the petition by the stamp reporter and the manner in which the endorsements must be made is also set out in this judgment. So the stamp reporter must make an endorsement that it has been
must
received.
record.
Yes.
I mean the formal presentation.
And in absence of that, there is no requirement, because what evidence would be led when it is apparent on the document is speaking for itself that this has not been done. And the lead judgment on this proposition, Lordship, is 2003 4 SCC 257.
2003 4 SCC
257. That 4 SCC 257.
Give a copy.
Yes.
I think the copy was handed over to Your Lordship.
Isn't the compilation?
No, a separate copy was handed over.
Can you give one in case if you have extra?
4 SCC.
Yes, 2003 4
257.
SCC.
Right.
Para 14, Your Lordship. Straight away. Para 14 at page 271. Around placetum B. An election petition when presented.
Reading from
Placetum
at page 271.
271. Placetum
There is
B.
no discretion in receiving election
There
petition.
is no discretion in receiving an election petition.
Okay.
An election petition, when presented, has to be received. It is a simple, definite duty. The date and time of presentation and the name of the person who presented, with such other particulars as may be prescribed, are to be endorsed truly and mechanically on the document presented. It is a ministerial function simpliciter. It can be safely be left to be performed by one of the administrative or ministerial staff of the High Court, which is as much a part of the High Court. It may be delegated or be performed through someone authorized. The manner of authorization is not prescribed. Now, Your Lordship, so therefore the Supreme Court has in fact given the very many details which have to be given in the endorsement when an election petition is presented. The date and time, the person who is presenting it, and then of course as per the rules of which are applicable to our High Court.
Like this judgment said, there's no discretion. There's no room for.
And Lordship, this is approving the judgment of the Guwahati High Court, which I had previously read.
This is emanating
From the Guwahati High Court. Yes. This is emanating from the Guwahati High Court rules. I stand correct. So therefore, Your Lordship, to answer Your Lordship's query as to whether or not there is a requirement of evidence, because the entire effort, so far as the election petitioner has been, so far as the election petitioner is concerned, has been to indicate to Your Lordship that this is a case of evidence, to prolong the lists between the parties. But whereas at the threshold itself, if it can be examined, and the purpose of the application under Order 7 Rule 11 and Section 86 would be defeated if in every case issues are framed and on issues evidence is led. One of the issues may be treated as a preliminary issue and thereafter the issue is to be decided. It would prolong the election petitions trial infinitely, and that, in my respectful submission, is not the intention of the legislature. Now, Your Lordship, finally on the last aspect of the matter, the judgment of Your Lordship has been subject matter of great debate so far as the election petitioner is concerned. In my respectful submission, Lordship, that creates no controversy in the matter. As I read it, Your Lordship has granted a simple permission on an application which asked for nothing more.
Yes.
The application did not. So first, if Your Lordship will grant me the indulgence and have the application filed by the election petitioner.
This case number?
27. This case 27.
27.
page 15 of the application.
Yeah, clear that all up. Page 15.
Yes, the prayer. In the aforesaid facts and circumstances, it is respectfully prayed that your lordship be pleased to issue notice to allow the humble application, and the applicant may be allowed to furnish the attested copies of election petition duly signed by the application election petitioner to all the respondents parties for the ends of justice before the commencement of hearing of the objection application being
Dismiss case.
Yes, this is the 711 Act. This is the prayer. Now, in any event, nothing can go beyond the prayer of the election petitioner himself. And that indeed is not what has happened in the present case. Because now imprimatur is sought to be drawn from your lordship's order by saying that your lordship has condoned everything. But if lordship has a perusal at the prayer, that is in fact not the subject matter of the prayer itself. What is being asked is very limited.
Yes.
Now your lordship will have the order of 11th August.
Yes.
First paragraph in my respectful submission covers the entire gamut.
Yes.
The instant miscellaneous application has been filed by the election petitioner under section 141, read with section 151 of the Code of Civil Procedure 1908 and section 81.3 and section 87.1 of the Representation of People's Act 1951 for granting leave to allow the applicant election petitioner to furnish attested copies of the election petition to the respondent as in the main election petition 2 of 2023, while furnishing copies to the respondents pursuant to the order dated 13th April 23, 40 copies of the same only was supplied. The respondent number 1 then on entering appearance had filed missed case being MCEP number 19 of 23, raising the issue of non-maintainability of the election petition on various grounds, which amongst others included the non-furnishing of attested copies of the election petition duly filed by the applicant. As such, by way of the instant application, leave of this court has been sought to allow the furnishing of attested copies of the election petition duly signed by the election petitioner. Then the submissions are recorded. Your lordship will find the finding at paragraph 6. On the non-supply of such attested copies, the election petitioner, therefore, by way of the instant application, is seeking to cure the said defects. As afore noted, objections to the application have been raised on the ground that it is barred by limitation, and the same cannot be considered in view of the fact that the hearing of Miss Case 19 of 23, Order 7, Rule 11 application filed by respondent has since commenced. On the first point, it is not disputed that the election petition was presented before the registry within the 45 days limitation period, and the same was accepted and registered. Substantially, therefore, the election petition was already on board. Notwithstanding the application for rectification of defects, the same was available for consideration. The contention, therefore, it was not complete in all respects and is now sought to be made compliant as per RP Act by the instant application, which is beyond period of 45 days. In the considered view of this court, is untenable and his contention is rejected.
Yes.
On the other aspect, though, it is noted that it is correct that an application is pending consideration and has been filed prior to the instant application. Presently, however, this court at this stage is only to examine whether the preliminary objection had been substantially heard before the instant application was filed. In the case of Anil R. Deshmukh, on this point, the Honorable Supreme Court, which is reproduced. In the instant case, the respondent number 1 had filed miscellaneous case under Order 7, Rule 11 on 14th June 23, and the matter then appeared on 11th July 23. On this date, the election petitioner then filed the instant miss case, seeking leave to furnish attested copies before the commencement of the hearing of the objection application. so and so. The orders are thereafter reproduced. Your Lordship will then come straight to paragraph 11. As the defect therefore being mere technical in nature, it cannot be held to be fatal to the main election petition, and as observed earlier, as there is substantial compliance with section 83 of RP Act, the technical defect is therefore curable. Accordingly, in view of these discussions and observations made herein above, the instant miss case application is allowed and is accordingly disposed of. So in my respectful understanding, as I see the order, Your Lordship has recorded at paragraph 1 that what is being sought for is only a permission of this Honorable Court to
furnish copies.
Now, as per my understanding, that permission may or may not have been required. They could have circulated it anyway. But they made an application seeking leave for filing that copy. Now, that has been allowed by this Honorable Court. No order of the court could in any event be passed beyond the prayer.
Yeah, and the question presentation was never addressed in any
And
stage.
that is why the entire emphasis at that point between all the parties was, my submission to Your Lordship was that the argument in 711 has commenced. Your Lordship disagreed with me. So therefore, if Your Lordship disagreed with me at that point that the 711 has not commenced, then naturally the issue of whether or not this defect can be condoned was not open. In fact, this order, in my respectful understanding, only furthers my contention that the issue of whether or not this is a condonable defect was not at all open before the court. Only issue was whether or not leave that has been sought can be granted. So my respectful understanding is that this is not a curable defect. And that issue has not in fact been examined by Your Lordship in the order.
Anything else, Mr. Sai? That's it.
This is my...
Yes,
sorry.
Mr. Any
Your Lordship, only one judgment. I'm so sorry. I'm so sorry. Only one judgment.
Para 13 of my affidavit, my lord.
Just
written objection.
I'll just pass on one judgment and then I'll conclude.
Can you give
I'll give you a copy. Because this is a recent 2023 judgment.
Your number?
What does it say?
Paragraph 12. It is well settled principle of law that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by the statute must be availed of. It is also a well settled salutary principle that if a statute provides for doing a thing to be done in a particular manner, then it has to be done in that manner and in no other manner. In so and so, it was observed that where the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner, following the provisions of law without deviating from the prescribed procedure. Paragraph 15.
Yeah.
Because this is an election dispute that is there before the Honorable Supreme Court. Para 15. There is hardly any need to reiterate the tried position of law that when it comes to statutory provisions relating to election law, jurisprudence on the subject mandates strict construction of the provisions. Election contest is not an action of law at law or a suit in equity, but purely a statutory proceeding, provision for which has to be strictly construed. The petitioner, having failed to make any application in writing for recount of votes as required under section 80 of the Nirvachan Niyam 1995, and having to fail to seek relief of declarations as required by Rule 6 or so and so, the election petition filed before the sub-divisional officer seeking relief of recounting of votes alone was not maintained. So therefore, nothing new in that sense. However, it's the latest restatement of the law in this regard. Lordship, these are my submissions for your Lordship.
Yes, my lord. Just in response to that, my lord, just I would like to
Lordship, I would
draw
oppose the
Lordship's-
rejoinder.
Only just no. Just only clarification.
Yes.
Page 13 of my written objection, my lord, to the miscase number 19.
That
Page number
is-
13, 1-3.
Okay.
Written objection filed on 10 July.
July. Miscase we have respond number 1. Respond number 1. Okay. Yes, page?
Page 13, 1-3, man.
1 second.
Page 1-3. Lordship got it. Lordship got it.
Yes, yes.
Yes. To this point, second para, my lord.
Yes.
To this point means regarding the points raised by the...
Now the other point as well.
Yes, my lord. To this point, the opponent petitioner back to...
Where reading from?
Pardon. Para 13, first para. Sub-para. Page 13, first subpara.
It is now the another point.
No, to this point, my lord. To this point, something like that. May I see, my lord? May I examine?
That's page 14, sir. That will be page 14.
Okay, sorry, my lord.
Oh, yes, to this point, sir. Yes.
To this point. The deponent petitioner begged to submit that election petitioner have fully complied with the above mentioned relevant provisions of law. The petitioner presented the said election petition before the stamp reporter with court fee ₹6 affixed to the election petition. That means the petitioner himself came and presented, this is my humble submission. And if it is denied by my learned friend, that is why preliminary issue has to be framed. That is what my proposition, my lord, as per the judgment referred by my learned friend, my lord. In the case of,
then why you think that stand that that it preliminary judgment that says that even if he is not present, then it should that the election president will be in proper form.
Yes,
that's the only thing. So
yes,
you are on presentation only.
And in the present form, my lord, because this
now,
is the
are you taking the stand that he was present?
No, he was present. He was present.
He is come and present himself.
Yes, because that is the because this is I'm relying the rules, my lord. Relying the rules of the High Court, my lord, which has been followed. He himself came in the campus, and by following these particular rules, says that
in the campus or before the stamp reporter.
No. He in the campus and he was waiting, and he himself entered, my lord. And then because his presence is not at all required. That is what they have said, and because he just went down because he was there. In the campus. In the campus means he was there inside the stamp reporter.
So beside this point, we have to examine.
Yeah, that is why.
CCTV footage.
Issue has to be framed in that case. If it is to be denied, because the prisoner himself came and presented this petition, and if it is to be denied, then issue has to be framed, my lord. I myself came.
I mean, see what's happened is that's why when we had heard this matter in the last occasion. Court has asked for report, stamp report. Stamp report is very bold when he says that it's been what is
the report? Also, I didn't see, my lord. Report in the under.
Because you see that yes.
Report what said, my lord? What it is said?
Who is stamp reporter? Demo. Huh? The stamp report is neither here nor there. Just as directed by Honorable Court Order date 59/2023,
yes,
hereby verify the stamp report of the main election petition affixed as a first page of petition as a check slip.
Yes.
That not in the.
That is why
not that is a.
Yes.
Like
in that case,
from the beginning when you took the matters, I all to the councils that election petitions are hyper technical.
Yes, my lord. In that case, my lord, my humble submission is that preliminary issue is to be framed and a stamp report has to be examined before the talk, my lord.
We'll see. That
is why, my lord.
What you have to say about the rules?
No, I have given my reply as it is.
What about the rules? What do you have to say about the rules?
Rules, my lord. Rules. What they have followed at the time of my juniors. They have referred here is the para number 3, the flag mark. Okay. The petition will be presented to the registrar within office hours on any working day, and his receipt showing the date and time of filing of the petition shall be obtained. The receipt shall also be indicate the date on which the petitioner or his advocate, if any, must appear before the registrar for removal formal defects. If any, the said receipt shall be Form A appended to these rules. 3. Any document other than the election petition itself, but connected with the petition which is not filed with the election petition may be filed either with the registrar or in the election branch with an endorsement in Form E appended to these rules of the date on filing of the same made on the first page of the document under the date of signature of the party filing documents or his advocate, my lord. I am not denying it because I myself present inside campus and I myself came, but when it is accepted by the stamp report, then only I left. That is my humble submission, and that is why, lordship, I have given in my affidavit also. I myself personally present. I myself personally present on that particular day, and because my line of submission is that as if I am not present inside the court.
No, but that is your line of submissions was like that. You said even if presented by someone else.
No. So not someone else. On that day I myself came.
Should not defeat. They should not be fatal to your election.
Yes, my lord. Even if
that is your submission.
That is even if it is not there also because the rule says there because it is not fatal, my lord. At the same time, my lord, if that is there,
the rule says see.
Yes, rule says.
Rule 3 again.
Yeah, kindly read again, ma'am.
Rule that 11. Rule 11. Read C.
3.
2.
2.
Yes.
2. Yes. petition will be presented to the registrar within office hours on any working day, and his receipt showing the date and time of filing of the petition shall be obtained. The receipt shall also indicate the date on which the petitioner or his advocate, if any, must appear.
So that's for removal of defects.
Yes.
But what we're talking about is the initial presentation of election petition.
Yes,
Okay,
my lord.
yes.
For the initial presentation, my lord, I myself came and I was present there. At the same time, my lord, if it is denied, that issue has to be framed, my lord. And the
So you're adopting an authorised
staff reporter
strategy
has
now.
to be examined. Staff reporter has to be examined in that case. That is why, my lord, my humble submission is that at the same time, I'm referring to in section 81. 81 again, my lord. Section 81 of the RPF. Section 81.
Yes.
81.1.
Yes.
An election petition calling in question any election may be presented. The word used is, my lord, may kindly see the word may, not shall. If the word shall is there, then it should be, my lord. But if the word may means may be present or may not be present also. That is the meaning, my lord. That is what Supreme Court says, my lord, in various judgments, my lord. The word may. If the word used may means, my lord, may be or may not be, my lord. And on one or more grounds specified in
May is refers to section 101.
Yes.
You see, it does not say that it may or may not be. It refers to, and what does section 101
yes.
say?
And regarding my presence, my lord,
What does section 101 say? I mean, it says
Yes.
may or may not be present. You see?
Yes.
101 means on what grounds?
Yes.
Where?
101, my lord.
Yes.
Grounds for which candidate either then the written candidate may be declared
together
to have
like
been elected. This one, simply, my lord. If any person
100 and 101.
101.
Yes. 100 and 101, both yes, on the grounds.
Yes. And
Anyway, yes.
if at all, the point raised by my learned friend that I was not present at all in the campus, inside the campus, then in that case,
a petition of section 81 says presentation,
Yes.
or it says that calling in question any election,
Yes.
that means can be filed
Yes.
on one or other grounds as mirrored on section 100 and 101. So 100 says, whatever this 100
Yes.
says, what? A corrupt practice, so on and so
practice,
forth.
that the affidavit is necessary.
So in the grounds that are there, I mean 100
Yes.
says, yes.
And since the Honorable Court has already condoned regarding the filing of the petition within 45 days, that
I don't think 81 will be applicable. Anyway, yes.
Yes, that has been condoned.
So your only submissions that he was present now.
Yes, my lord.
That's the baseline.
I'm not, because that is why my affidavit, my lord. I'm saying.
So we
according
went
to
through
my
all
affidavit.
this rigmarole for.
Yeah, according to my affidavit. According to my affidavit. Because I'm saying my affidavit, my lord. I'm submitting
Okay.
according to my affidavit. And if at all, if this point is raised, then in that case, the issue has to be framed, my lord. And our commissioner and everybody who is in there, that has to be examined, my lord. That is my humble submission, my lord. If it is to be denied.
Okay, right.
Obliged, man.
Yes. Heard my counsel, judgment reserved. You file your bullet points. So at least I can, because call it probably, because now he's given alternative ground, which is.
But Lordship may note that the alternative ground is present on campus. I have no difficulty with that.
No, I was present.
Present on campus.
I'm sorry, I was present.
Will not
I was
meet the
present.
requirement.
Yes, this even there's one matter also regarding those service in a tea shop. Service of notice.
Because technical issue may not be bar the election petition, my lord. And when debarring the election petition is a threshold, my lord.
That reflects on the council handling it. Yes, when will you file the bullet point?
Lordship, within a week.
Yes, a bullet points within a week.
Oh, yes.
If you file a bullet points.
May me also file, my lord.
Yes, of course.
Within how many days, my lord?
Within 1 week.
Yes, obliged.
I don't want lengthy written arguments, just bullet points.
Yes, sir.
Bullet point argument. Yes.
Please, Your Lordships. Your Lordships, I'll be brief with respect to my submissions because my learned friend has already put all the relevant judgments.
So see my presentation only.
Your Lordships, it's except the 2 points that there is no issue of limitation in my case and no application as such was made by the opposite party with respect to
For?
curing the defects. So except for the 2 parts, my submissions would be similar on the grounds of what my learned friend has argued, Your Lordships.
Okay. You adopt his submissions. Yes.
Your Lordships, in the present case also, the application has been moved under Order 7, Rule 11, read with Section 86 of the Representation of People.
Miss case number?
Please, Your Lordships.
Miss case number, how much is your son in application? 18, okay, yes. Right. Is the first time it's been taken up?
Please, Your Lordships.
Yes. Yes.
Your Lordships, I will read the statutes. First, Section 80, Chapter 2 of the Representation of People Act that deals with the presentation of election petitions to High Court. Section 80 says, no election shall be called in question except by an election petition presented in accordance with the provisions of this part.
Yes.
Section 80A, further, the court having jurisdiction to try an election petition shall be the High Court. Please, Your Lordship. Now coming to Section 81, which specifically deals with the presentation of the petitions. An election petition, that is Section 81, Clause 1 of the RP Act, an election petition calling in question any election may be presented on one or more of the grounds specified in subsection 1 of Section 100 and Section 101 to the High Court by any candidate at such election or any elector within 45 days from but not earlier than the date of election of the returned candidate, or if there are more than one returned candidate at the election and dates of their election are different, the latter of those 2 dates. Your Lordships, I'll stop here. In the application which I have presented before this Honorable Court, Your Lordships, there is it's very apparent on the part of the reply also which has been filed by the opposite party that there is no compliance with Section 81 Clause 1 of the Act, Your Lordships. There has been no presentation by the petitioner personally before the stamp reporter, Your Lordships. So now moving on, Your Lordships, now I will be reading Guwahati High Court rules, that is Chapter 8A, Rule 1 at page number 28 of my Order 7, Rule 11 application, Your Lordships.
You will next the rules, correct?
Please, Lordships.
The rules are next here.
Please, Lordships, page number 28
It's very similar to the earlier
of my
application.
711.
Yes.
Rule 1 says, an election petition under Section 80A of Representation of People's Act may be represented, duly verified in the form prescribed under Section 82 and Section 83 of the said Act before the stamp reporter of this court with a court fee of ₹6 affixed thereon within 45 days from the date of election of the returned candidate, or if there are more than one returned candidate at the election and the dates of their election are different, the latter of those 2 dates. Your Lordship, there is a reason why I am reading Section 81 Clause 1 along with Rule 1 of Chapter 8A Guwahati High Court rules. Your Lordships, in both the provisions, it is very clear that the election petition has to be presented, in fact must be presented by the petitioner himself personally before the stamp.
Yes, we have gone there, yes. I mean, show me how he was at present.
Please, Your Lordships. Yes. That is in their reply.
Where's the reply? Show cause reply 18, right? So, Mr. Jindal was in the campus or he was
in the registry before the stamp report?
Okay.
A specific statement on the affidavit.
Now let's see where what objection. Where did he say? Where?
Your Lordships.
Yes. Show cause reply for me. Okay. Yes.
Please, Your Lordships. Before that, I would say, first of all, there is no endorsement by the stamp reporter, as my learned friend has already argued at length. That's why I will not take much time of this honorable court, Your Lordships.
Yes.
There was no endorsement, no date, no name, no time, no signature is present there on the petition which has been presented as alleged by my learned friend by the election petitioner. Your Lordships, there is no endorsement of the stamp reporter by the stamp reporter. I repeat, Your Lordships. Para 11 at page number 7 of the reply, Your Lordships.
Para 11.
At page number 7 of the reply to the order 7 rule 11 filed by the opposite party, your lordships.
Para?
This is para 11.
At page 7.
Please, your lordships.
Yes. The averments made so and so. Yes.
It is humbly submitted that the petitioner herein has himself personally presented the election petition before the assistant registrar of this honorable court on the date of filing, that is so and so, and as such there is no contravention. Your lordship, on this point, in this particular para, no averment or no submission has been made by the opposite party to the effect that this particular assistant registrar is the stamp reporter. Your lordships, in my application, order 7 rule 11, where is my application? My application. In 711 application, your lordships, at page number 37
Okay.
of the application, and that is point 13, serial number 13.
Point 37. Page 37, yes. Point 13.
Please, your lordship.
Assistant Registrar 3.
Assistant Registrar 3.
Yes.
Performing duties with regards to filing and stamp reporting in judicial section and in charge of the record room, your lordships. So, Assistant Registrar 3 is the concerned registrar who has been appointed as the stamp reporter by this honorable court, your lordships.
Now, who's that person?
Please,
not,
your
not this
lordships.
person named here.
Your lordships, in the particular para, this has not been, no submission has been made to the effect that this particular person is the stamp reporter.
Okay. We noted that, yes.
Should I say it or not? Your lordships, however, unofficially we have come to know that Mr. Democritus Marbanian is the stamp reporter.
Okay. Yes.
So, your lordships, my first point was that there has been no personal presentation before the stamp reporter. Even for the sake of argument, if they are saying that there has been personal presentation, then that is not before the stamp reporter. Secondly, your lordships, moving section 81 clause 3. Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. Your lordships, in the replication to the reply filed by the opposite party to order 7 rule 11, I have attached the copy which I have been served with. That is at page number 28, your lordships.
Yes.
Your lordships, it is apparent from the copy which is right before your lordships, there is no true copy and no attestation.
Page 28.
Please, your lordships.
You mean the petition? It's page
Page 28 of
28
the
is-
replication to the show cause.
The 28 is the notice.
Yes, your lordships, it starts with there.
Okay.
That is the served copy. That was the copy which was served on us, your lordships.
Okay.
Relevant page would be, your lordships, page number 30,
Okay.
where the copy of the petition begins.
No attested copies were served on you.
Please, your lordships. It has not been true copied, your lordships. In fact, the pages, the documents also start from page number 63.
Yes. No true copies furnished or served. Yes.
Documents, your lordships, start from page number 33, your lordships.
Okay.
63, your lordships, my apologies. Page number 63, the documents start.
Yes.
There is no true copy. There is no attestation, your lordships.
Yes. John Marak was the petitioner.
Please, your lordships.
Right.
But it has not been true copied by.
Right.
In fact, Your Lordships, I have also attached the certified copy. We had applied for the certified copy of the petition, which was filed before this Honorable Court. That is also there, Your Lordships. And that starts from page number 158. This copy has also not been true copied and not truly attested by the petitioner himself.
He didn't sign every page.
Your Lordships, it is not true copy.
Okay. No, the annexures.
Annexures also, Your Lordships.
Certified and true copy is in here, but not signed by this. Not the
Page
candidates.
number 181,
The candidates signed on the side, but.
Your Lordships, in that case, in fact, both the copies are not even identical.
The one filed and the one served.
Yes, Your Lordships. That is relevant.
Yes.
Because, Your Lordships, there are few pages on the copies served on us. There are those few pages are notarized, and few pages of the copy which has been filed before this Honorable Court has not been notarized. In fact, Your Lordships, I have also mentioned in the.
You do one thing, you make out the list of the defects.
Please, Your
And
Lordships.
then let him reply to that, because this is if this is correct, Mr. Jindal, there's no true copy or no.
It's not correct. I'll reply.
Is that correct? Okay. So are we here to be till 4 o'clock?
Looks like it, my lord. Looks like it because of the nature of the allegations against me, my lord.
Yeah, then we'll take it tomorrow. Because we're a bit lawyers are waiting. You'll be here tomorrow?
Please.
Can you just do one thing? Just make a small checklist of what you see are the deficiencies. Correct?
Please, Lordship.
And
In
that's
fact,
so
Lordship, I have also
we
mentioned
can
in my
compress, because substantially the arguments by Mrs. Sai will cover your arguments also with regard to section 86 and the rules of the High Court, and also the judgments which have been placed. So with regard to the law, I don't think we need any more judgments, only on the deficiencies and whether they can answer those those deficiencies which you have flagged. That's all. Right?
So if my friend is preparing a list of defects, if I could request an advance copy before the hearing tomorrow, so that it's easier for me to respond.
Lordship, we'll serve them in the morning, Your Lordship.
Very well.
List for further consideration tomorrow.
Item number 8.
I just let time away. I'm so beautiful. Yes, Mr. Karanlang.
Lordship, we have filed.
Very good.
All the state
You only for number 4.
Lordship, for the state respondent.
What about 1, 2, 3 have been filed?
No, all the state respondent and also the private respondent, they have filed the affidavit also.
But come record me, pa?
Number 8 ne?
Belum record ini dia orang cakap ni. Every behalf to not it's not yet been filed. No. Belum record ini. When did you file it? Where's MS Lalu? When did you file it?
The 12th of September.
Only 1, 2, 3, go.
Number 6.
Okay, that's correct. What about 1, 2, 3?
Number 6.
1, 2, 3, you won't file. Mr. Karanlang, also you took time to file on behalf of all 1 to 4.
Lordship will be relying on the affidavit number, respondent number 4, Lordship.
Yes, Mr. Sarba.
Lordship.
What about MS Waniang?
Appearing on behalf of 6, 7, 9 and 10, we have
Yes.
already filed our counter.
Already filed. Yes. File rejoinder then.
Lordship,
MSH Karanlang submits that the affidavit filed on behalf of number 4 Lordship relied upon by the other respondents 1, 2 and 3. Stop, Mr. P.D. Salma. Please allow 2 weeks time to file rejoinder of the affidavit filed by all the respondents.
Item number 9.
Anyone unserved?
Lordship, no.
Sure.
Yes.
We take your word for that. If it was found out later on not unserved, then your case will. Anyway. Yes.
What's the response?
Mr. Deb, rejoin the file.
No, I'm praying for some further time of 3 weeks. No, because certain malord allegations.
No, how many times have you taken? How many?
Three.
Third time. Third and final chance.
3
Third
weeks.
and final chance allowed to Mr. is there to file a joint affidavit?
I'm praying for 3 weeks, my lord, because they have made serious allegations in the affidavit which needs instructions, proper instructions.
Yes, third and final opportunity of 3 weeks granted to Mr. S. to file a joint affidavit. Yes.
Much obliged.
Item number 10.
Yes, from town.
Lordship, in this matter, in fact, we've just received the Parawise comment, so I'm praying for further 3 weeks time.
No objection. As prayed for the 3 weeks time granted to S. from town or file affidavit.
11.
Your Lordship,
File.
Your Lordship, in this matter, I'm praying for further 2 weeks time to file my rejoinder.
Yes, MS Ivania prays for allowed 2 weeks time to file rejoinder. Court Ibu Awalan.
12.
Don't laugh. Nay.
Please, Your Lordship.
Yes.
Lordship, here the matter was already rendered infructuous before filing of the petition, my lord.
Oh, doesn't this?
Lordship, may I be
But you have suppressed the fact, my lord.
this is not a suppressed fact. In fact, this document, it seems to be manipulated, Your Lordship. You see this.
What do you mean seems to be manipulated?
Lordship,
It can be or not.
No, Lordship, this kindly have a look this one. I'll be filing a short reply to this because this is the annexure 5.
What does it say?
Page 18, page 18 of their affidavit.
Don't get excited. Let's see the affidavit first. That you're so excited about. What does it say in the affidavit?
In their affidavit, they have enclosed the formal work order issued to the private respondent. This is the same letter. Same letter in this page 18, and this is different from the which I get it the work order from the this one. Lordship, this is the same letter, same date, but the amount is different, Your Lordship. Yes, can you give it to? How can it be possible, Lordship? And you just have a look at page. Another, that's a type copy, Lordship. Type copy of this one is there's I have type it, Lordship.
Lordship, the same. No. Kindly come to annexure number 4, my lord. This is the same order.
No. See,
not same order. Annexure 8 of the affidavit filed by the.
How can it be? The approximate value of work is 7 lakh. In this one, it's and the letter numbers are same.
Same letter number also same, date also same. Everything is same. Only amount is different. It cannot be. It cannot be the same, Lordship. There is something wrong in that. The record may be called for, Your Lordship.
Who's the state?
This is the affidavit filed by the state respondent. They have annexed.
You filed this,
Lordship.
Road has been submitted that yes.
Lordship, I would like to bring one thing before the Lordship. The Lordship regarding the way the has been brought in the newspaper, Your Lordship.
This is regarding another case where the contractor.
The same order was enclosed, my lord.
If Lordship kindly see, meanwhile.
This is there is not bearing anything.
Please to come to the.
So you file FIR also after this?
Not against this in this case. Another case, in the case of another contract, he has got the contract whereby the officers have taken a bribe of 30.
So you said SDO is selling contracts. That's your allegation.
Not in this case.
As you quoted, what you say?
Can you see, Your Lord?
See, as such, you see, I deposit the money in her account through Google Pay, but planning my bills had to be cleared. On that day, I thought that officers may have the legal right to demand money for the services. So you thought that they also have legal right to demand money?
No.
To get your bills.
In the FIR, he has filed the FIR some other contract, not in this case. Not in this case, Your Lord. He has got another contract where the bill has to clear the bill. There is a completion report. The completion report. This is nothing, Lordship.
Yes, no, take down, yes. It is not Mr. A.G. Movement who has appeared at the appearance. We have the respondent number 4 has 4. This is 4 submits that the matter has been very infructuous.
See, Lordship.
But however, serious objections been raised by Mr. P.T. Sangma, who has produced a letter similarly dated.
Similarly dated, and the letter number also same.
This was affidavit. This is your affidavit.
This is affidavit, both of them has enclosed the same. This is my affidavit, my lord.
To the veracity of the documents annexed therein. Stop. Accordingly, he prays for and is allowed to bring the same.
Lordship.
What do you call it? Questionable document.
I said this it seems to be manipulated.
Yes, you file it.
Lordship. Just
Then if that's correct, Mr. Shura is very serious. How can it be same letter number and two amounts? This after 2 weeks, yes.
Lordship. At the meantime, Lordship, the record may be called for because they have backdated the bank draft.
Copy of
Lordship. Lordship.
Yes, next matter.
Lordship.
Lordship, I'm appearing for respondent number 2 in this matter, and I will not be filing any affidavit, Lordship, in this matter. It's not required.
3 and 4.
2 weeks time to file an affidavit. Your Lordship, I'm appearing on behalf of respondent 1. You will not be filing any affidavit.
MS Shalam, Council 3 and 4 prays for the 2 weeks time to file affidavit. Is submitted by this council for support number by MS Rum Thao for number 1 and P. Agarwal for 2 that no affidavit will be forthcoming from their side. Yes, this accordingly on so.
14.
Obliged, Lord.
Yes. No, so deep for me, no.
Lordship,
Yes.
in this matter, my lord, I'm maintaining appearance on behalf of number 4, my lord.
Mr. General, there is a pen on 4. So as such service complete. What time you want to file affidavit?
Lordship, in fact, there is a serious issue of maintainability of this petition.
So whatever.
I'll raise that issue first, my lord, through a small, short affidavit on the point of view.
He submits that we put to file a short affidavit because on the question maintainability incident petition. Prayers allowed. 2 weeks time granted. This also. Yes. MSZ number 3 submits that the affidavit for half the state will also be filed within the set period. Will be filed within that period, yes. Yes.
15.
Obliged.
Yes.
May it please your Lordship. Lordship, in this matter, we need some more time, your Lordship. We have the instruction now. We'll file the affidavit, your Lordship. 2 weeks time, can be allowed.
Further 2 weeks time to file.
15 and 16, your Lordship. Apply, your Lordship.
Hearing. Supplementary list. Item number 3.
Any other hearing matters done? 215.
215.
Because we have to pass orders.
Yes, yes.
Any other hearing matters you ready?
19. 19.
Item 20 is there before your lordships. This is that matter, my lords, where that between the bank and the petitioners, lordships had heard it, but this will take a little bit of
Escrow
time.
account.
Escrow account, my lords. This will take a little bit of time.
We don't get Mr. Datta every day.
No, my lords, I had requested Mr. Datta, so he was also here.
Can you get another date because I'm not.
My lords, we can quite see that.
Yes.
You would want to.
But
Could we have it on the
Mr. Sen's matter I have to take up.
Could we have it on the 6th, my lord, subject to your lordship's kind convenience?
20th on the 6th as requested regarding the worries. Yes, Mr. Jar,
My lord,
ready with the hearing?
my lord, it is they had to provide the copy. Copy of the finding along with the court of inquiry, my lord.
They have not given.
They have not provided.
Not received, my lord. I'm praying for some more time, my lord. 10 days time.
Mr. Item number
19, my lord.
19. Dr. N. Musika prays funds allowed further 10 days time to produce the findings of the court of inquiry. Lives thereafter and so on.
22. 22.
Yeah.
Your Lordship.
We are ready, my lord. This petition, we are saying that it is entirely filed in oblique motive.
Which one, 22?
22.
Your Lordship.
Lordship, what has happened is, Lordship will remember, this is in connection with a fishery.
Settlement of fishery, Your Lordship.
Now what happened, my lord, because of...
You file affidavit?
Yes, yes.
Who's number 5?
Pleadings are complete, my lords. I appear on behalf of...
Hey, urgency.
Pardon, Your Lordship.
Any urgency?
There is a little urgency, my lords, in the sense...
You're running the fishery.
My lords, this is a matter that has come umpteen times before your lordships. On the last occasion, your lordships dealt with the matter, disposed it of. There was a dispute between myself and
Respondent 4.
friend then. My lords, and the matter was referred back to the district council that you resolve it amongst yourselves because we both had 10 years running.
Yes.
District council comes to a finding, Millet, saying that you run it for 7 months and I
half,
run
half.
it for 11 months. So for the first 7 months, Millet, there is no objection, nothing, everything is fine. Now, after that, Millet, when he has to surrender it and then I am to run the show, that's when, Millet, his brother-in-law is before your lordship saying that the
Tender should be called and
That
this
is not
settlement was illegal.
That is not correct,
In
Your
fact, he
Lordship.
has never participated in the tender. He has
Then
never
who are
run
you?
any
Who pressures
proceeding.
him?
no locus.
Your
No
Lordship.
locus, absolutely oblique motive.
Then
madam.
will
And your
then will
lordship-
inflict heavy costs on you.
No, Your Lordship, that is not true, Your Lordship.
If he really
If
had
your
the
lordship-
obligation, he would have
If
come
you
when his
find it's
own
surrogate
brother-in-law was running.
kind of filing a writ petition, we will inflict costs.
That is not true, Your Lordship. If Your Lordship will come to the...
Now you're not running it.
No, Millet. I am in settlement of the thing, but there's challenges there before your lordship.
So why are you not settling with him then allow him to run it?
Settlement is
Settlement is already there, Millet. They've challenged that order before your lordships after 7 months.
But Your Lordship,
If she really had a grievance, she would have raised the grievance when his own brother-in-law.
No,
was-
exactly. No, the thing is that now you're finished with the system.
No,
also.
my tenure is running.
Hers is
So
starting.
you're operating
Just
fishery.
started. Just started.
Then we'll hear after some time. Yes, list after 2 weeks on the prey of so and so for Krishna. If you're not running it, then you would have heard it. But that is, but remember, will inflict costs. If it is
That is not correct, Your Lordship. I have no relation.
you're not even a
at all with
tenderer, then what grievance would you have?
Pardon, Your Lordship.
You're not even a
Actually, Your
tenderer.
Lordship, I wanted to participate in a fresh tender, but when the district council has not floated any
We'll hear you,
tender.
23.
Your Lordship.
23.
The nectar matters.
Nectar matters, Millet.
We'll have it already after pujas.
As your lordship.
It's a matter of puja vacations. When MS will be available in person also. Yes, interim orders they continue. Or they're continuing.
Your lordship, direct continuance.
Until further orders, yes. Yes.
Obliged. That would cover Malad's 24 and
25, 26.
24, 25, 26.
27.
Obliged.
These are the matters relating to gratuity and dues, etc. My lord. We have paid 28. If I can place this chart, my lord.
What is this?
This is regarding payment of the outstanding dues of my lord. We have paid about 28 crore rupees from May to August.
28 crore.
28 crore rupees, my lord, and total outstanding dues, my lord. If you lord will see. First chart is, my lord, is the payment made, amount of LEB paid.
LEB means?
Leave encashment paid with effect from May 2023 to August 2023, my lord, 28 crore rupees. And the second chart is, my lord, the total.
How do you know whether the petitioners are?
They are being paid in that that manner, my lord, and we will be clearing this amount. We are clearing. We have paid 28 crore rupees. Balance is 138.41 crore rupees, my lord. So we will pay the amount. That is what we will give you. We'll place the chart, my lord. We'll place the chart.
Anyway, my lord, it cannot be done today. Only my anxiety is this thing, my lord. Now more than almost 2 years, my lord, these matters are pending.
No, they already paid you. They're paying you.
Only 50%. Nothing else thereafter happened. 50% in the initial stage we got, my lord. After that we have not got anything. Nothing at all.
You agree that you've been paid this amount, some amount.
Because we are paying.
The leave encashment you've been paid.
50%, only 50%.
When was this paid?
Recently, I think.
Recently, then?
We have been paying. We have been paying. We are trying to.
Doesn't mean that it's a stone wall. I mean, like you've been stone wall.
You can't suffocate
Yes,
us
a
to
chart has been produced by Learned Advocate General appearing for the respondent corporation that payments of leave encashment have been advanced, an amount of which 28 crores has since been dispersed. 28 crores or 28.7 crores have been disbursed. He submits that a detailed chart will be filed indicating the amount received by the petitioners. How much have you got? Why didn't you come?
No, my lord, that is already your lordship. But regarding the other amount, my lord, we cannot be left to this uncertainty. Now he is saying a list, my lord. Now that may take 3, 4, 5 years, my lord. Lordship has acknowledged.
You know what problems they have. It's not that it's your right. It's not a question that
this is exactly my lord. This is my right, my lord. I'm before the court for enforce my right, your lordships.
Of course. Just after 2 weeks, yes.
Okay. They pour me the card also, my lord. That letter is there, my lord. That letter.
Regarding?
They pour me the card, that Weybridge matter. My friend is appearing that matter. So I place that letter, then your lordship.
No letter?
Later, your lordship, that letter which my friend
Yeah,
was
this
pointing out that regarding that matter.
I don't know what is it. 26.
20th June, my lord. Give me yes. I am directed to refer to your letter on the subject cited above and to inform you that the government has conveyed its approval for extension of agreement dated so and so only and no more extension beyond the mentioned date. This has the approval.
That
of
is what
government.
my grievance is actually. Nothing new here. That is exactly my grievance.
That is the
my lord,
thing which I have to
only your lordship. I don't know. Lordship will take it up at 2:15. 2:15.
Your lordship has heard us.
No. My lord has said that you will take it up at 2:15.
Yes, no, we're going to pass orders. We're not disposing of the entire matter because it's a very interesting matter. Because this is a hodgepodge between license, lease, commission.
Only
that
point
has to be that
only
by the
point
court.
which I have to mention
some
is
better
that only point only
one thing, Mr. Advocate General. Yesterday the court said give us.
Your lordship, what?
Who will operate in interim?
Probably.
That's all. It's just for 2 weeks.
Your lordship, if your lordship has heard the matter substantially.
No, only for 2 weeks we're putting arrangement.
Your lordship may pass the status quo because concession on my part will be difficult, and that is
Then
for
we
2
pass orders,
weeks.
yes.
That is. Status quo is status
quo as on today.
That is what you are getting.
Status quo has to be as on today. It can't be status quo after 30th.
Tomorrow is the deadline.
Not tomorrow. Tomorrow is 29th.
But your lordship, only thing is that the prima facie case, balance of convenience, and the agreement is over.
The only concession why this court entertaining this petition is only the ground that whatever it is, he has some document, right or wrong. He should have been offered some kind of a semblance of a.
I will satisfy your lordship on that point also. Your lordship, at the stage of final hearing.
Yes. I'll pass orders.
Yes, sir.
Then we won't sit to 2 o'clock unnecessarily.
Not requirement. Lordship will passing the status quo. Your lordship.
I got this.
That will be your lordship for 2 weeks.
Status quo and
In the next day the matter is listed. So make hay while the sun shines. Yes. Thank you.